Estate planning, why you should do it, and how to involve your heirs from the get-go. Find out how to prepare your heirs for a successful wealth transfer after you're gone, and learn why you should even consider planning your estate in the first place. Keep in mind that clear and open communication plays a vital role in protecting, preserving, and growing your money. Watch the show now. Welcome back, folks, to another edition of Sweetie Kiwi. How you doing today? I hope you are doing fantastic. I'm doing marvelous, if you were to ask me. If you are doing as great as I am, go grab a cup of coffee or tea or vodka and let's roll. Today I want to talk to you about estate planning, why you should do this, and how to involve your heirs from the get-go. Let's go to the fundamentals first. Estate planning at a glance. Estate planning is a systematic approach to getting your personal and financial affairs should you become mentally incapacitated or die. The basic legal document necessary to plan for death is a last will and testament, which contains a written set of instructions to your loved ones as to how you want your estate to be distributed after your death. Reasons to hire an estate planning attorney. When considering if you need to hire an estate planning lawyer, consider this. Estate planning is serious business. One wrong word or one missing signature can change the entire intent of a will or trust. Aside from this, the three reasons listed below should be enough to convince you to go out and find and hire a qualified planning attorney, estate planning attorney, to draft your estate planning documents. Estate lawyers are necessary since state laws rule estate plans. State laws are very specific about what can be and what cannot be in a will, trust, or medical or financial power of attorney, who can and cannot serve as a personal representative, trustee, healthcare surrogate, or attorney in fact, who can and cannot be a witness of a will, trust, or medical or financial power of attorney, and what formalities must be observed when signing a will, trust, or medical or financial power of attorney. For example, in Florida, a personal representative must either be related to you by blood or marriage, or if not, then a resident of the state. Time and again, experts have seen wills of Florida residents that designate a friend or attorney from out of state as their personal representative. This non-resident, in this case, non-relative, simply cannot serve and in fact will not be allowed to serve in Florida, for example. So working with a qualified estate planning attorney will help you to avoid this kind of simple and yet costly mistake. There is in law an old Latin saying, caveat emptor, or buyer beware. This certainly applies to estate planning. If you think that you will be saving a few dollars by using forms found on the internet or in a do-it-yourself book to prepare your estate planning documents, then your family will be in for a rude awakening when they learn that part of or all of your will, trust, or medical or financial power of attorney is not legally valid and would not work as you had anticipated. So thousands of dollars will then be spent by your loved ones working with a qualified estate planning attorney after the fact to fix your mistakes. So you got to really think deep about this. Now, another thing that is very important is that estate lawyers can help sort out complex family or financial situations here. Take a look at your life and your asset to see if you fit into one of the following categories. You are in a second or a later marriage. You own one or more businesses. You own real estate in more than one state. You have a disabled family member. You have minor children under the age of 18. You have problem children, which a lot of families have, especially some rich families that I know at least. You don't have any children. You want to leave some or all of your estate to charity. You have substantial assets in 401ks and or IRAs, and you were recently divorced. You recently lost a spouse or other family member. You have a taxable estate for federal and or state estate tax purposes. Now, this is a non-exhaustive list here. There are many more. What I'm trying to say here is that estate planning is it's serious business, and you want to have an expert around you by your side, unless you yourself have acumen in estate planning. If not, reach out to a local lawyer. We've done a show about how to find a lawyer, and you might want to double check that show. It will give you a clear path, a clear roadmap as to how to find any type of lawyer, including an estate planning lawyer. All right, I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. We are still having a conversation here around estate planning, and I'm explaining to you why you should do it and how to involve your heirs from the get-go. What are the reasons why you need an estate plan? But before I just continue here, please consider subscribing to our channel and turn on the notification bell so that you are aware whenever we drop a new show. And this kind of shows are released periodically, but we drop shows every single day, rain or shine, on a variety of topics, including estate planning. Comment below if you have questions or you want to share your experience with us. We really appreciate that. Also, like this content and share if you believe that somebody might need to have this kind of content. Share it. Reasons you need an estate plan. There are a variety of reasons why people decide to meet with an estate planning attorney and create an estate plan. However, there are five key reasons. Number one, avoid probate. What is probate? A probate is the process of validating a deceased person's will and placing a value on their assets, paying their final bills and taxes, and distributing the rest to their beneficiaries. Avoiding probate is by far the most common reason why people seek out the advice of an estate planning attorney. While many have never dealt with probate, they still know one thing. They want to avoid the probate at all costs. This stems from probate horror stories covered by the media or told by neighbors, friends, or business associates. For the vast majority of people, avoiding probate is a very good reason for creating an estate plan in the first place and can be easily achieved. You don't want the government to be in your business. That's the bottom line here. They also need a plan. You might need an estate plan to reduce estate taxes. The significant loss of one estate to the payment of state and federal estate taxes or estate inheritance taxes is a great motivator for many people to put an estate plan together. Through the most basic planning, married couples can reduce or even possibly eliminate estate taxes altogether by setting up AB trust or ABC trust as part of their wills or revocable living trust. Also, a variety of advanced estate planning techniques can be used by both married couples and individuals to make the estate or inheritance tax bill less burdensome or completely go away. You can create a plan. You need a plan if you want to avoid a mess, right? A lot of people seek the advice of an estate planning attorney after personally experiencing or seeing a close friend or business associate experience a significant waste of time and money due to a loved one's failure to make an estate plan. So if choosing someone to be in charge if you become mentally incapacitated or die, and deciding who will get what, when they will get it, and how they will get it, will go a long way towards avoiding family fights and costly probate court proceedings. You can also establish an estate plan to protect beneficiaries, right? There are two main reasons why people put together an estate plan to protect their beneficiaries. They want to protect their minor beneficiaries or to protect adult beneficiaries from bad decisions, outside influences, creditor problems, and divorcing spouses. If the beneficiary is a minor, all 50 states have laws that require a guardian or a conservator to be appointed to oversee the minor's needs and finances until the minor becomes a legal adult, usually around age 18 or 21, depending on the laws of the state where the minor lives. You can prevent family discord and costly legal expenses by taking the time to designate a guardian and trustee for your minor beneficiaries. Or if the beneficiary is already an adult that's bad at managing money, or has an overbearing spouse or partner who you fear will squander the beneficiary's inheritance or take it in a divorce, you can create an estate plan that will protect the beneficiary. The last reason why people establish an estate plan is to protect assets. Remember, I'm giving you five reasons here. Avoid probate, reduce estate taxes, avoid a mess, protect beneficiaries, and the last one here is to protect assets. So asset protection planning has become a significant reason why many people, including those who already have an estate plan, are talking to estate planning attorneys. Once you know or suspect that a lawsuit is on the horizon, it's too late to put a plan in place to protect your assets. Instead, you need to start with a sound financial plan and couple that with a comprehensive estate plan that will, in turn, protect your assets for the benefit of both you during your lifetime and your beneficiaries after your death. You can also provide asset protection if that's what you want. Really, you can actually provide asset protection for your spouse through the use of AB trust or ABC trust, and your other beneficiaries through the use of lifetime trust. This can also include electronic assets, by the way, platforms, websites, and so on and so forth. All right, I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Q. We're also having a conversation here around estate planning, why you should do it, and how to involve your heirs from the get-go. So I've already explained to you the 5 reasons why you should do estate planning, and now let's talk about how you can involve your heirs. You can involve the beneficiaries. This is very simple, but it's a little convoluted, so I'm going to go straight to the point. Tell your heirs about your financial details, because usually people avoid talking about their personal finances, even with loved ones. But you need to be sure that your heirs are familiar enough with the details of your estate so they can assume management or oversee the assets once you're gone. You want to involve your heirs in the estate planning process. This will be very beneficial because it will help to generate dialogue about how your estate will be passed once you are gone. This is also a good time to work on your family's mission statement. If you're passing along a business or large investment, you should talk with your heirs about your values and hopes for these assets. Clarify now so they aren't left guessing later. Organize your financial documents and keep them in one location. You don't want your heirs having to scramble to find different parts of your estate, right? That's not what you want. So you want to keep all this information in a safe location and let your heirs know where it's located. Speak to a trusted family advisor. This could be a lawyer also, or a banker. This can play a vital role in ensuring a successful wealth transfer. All right, by engaging the entire family, a family advisor can help craft a plan with a long-term goal of helping the next generation thrive, which is what you want. You want prosperity for your offspring for many generations to come. Many family advisors will conduct speaker series about raising financially responsible children. They can also provide advice around philanthropy, to introduce gift-giving strategies or creating a family foundation, right? So they can also help build you as the grantor, the trust maker here. You can help build the relationship between your heirs and your financial team. I'm talking financial advisor, estate planning attorney, and CPA. By helping forge this relationship early, your heirs will have resources to turn to if the transfer of wealth gets complicated. It will also help prepare them for their future roles and all that the inheritance brings. So let's say if you are the recipient of an inheritance, it is critical to use your newfound money wisely, right? This is absolutely not the time to move into a mega mansion, buy a yacht, or go on extravagant shopping sprees, right? In fact, your lifestyle really should not change at all. The money you do receive can be used wisely in the following ways. You can eliminate debts, right? This is a great way to use some of your wealth transfer. You can add to your emergency fund of 6 months, 9 months, or 12 months expense. You can save for higher education. You can invest in home repairs or equity producing investments. Even if an inheritance truly constitutes extra money, still save 80%, right? So the bottom line here is that strong family communication is the key to a successful wealth transfer. And the earlier you start the process, the better. All right. So this is it, folks. Today I was just talking to you about estate planning, why you should do it, and how to involve your heirs from the get-go. I spoke about the fundamentals of estate planning, the reasons why you need an estate plan, and ways you can involve the beneficiaries from the get-go. Thank you so much for listening to this conversation. I will see you next time. But until then, remember, stay marvelous.